No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, Ethically Bankrupt, the Judge David R. Jones Sex Scandal. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Today's program is about Judge David R. Jones, who was, until he resigned in November 2023, the Chief Judge of the United States Bankruptcy Court for the Southern District of Texas located in Houston. I am sure many of you already know something about the sex scandal that brought down Judge Jones, because not only was it covered extensively by the legal press, but it also was the subject of high-profile articles in the Wall Street Journal and the Financial Times. Some of the most salacious headlines were, "Judge turns Houston Bankruptcy Court into profitable venture for girlfriend." This judge made Houston the top bankruptcy court, then he helped his girlfriend cash in, and my personal favorite, "Sex, Lies, and Bankruptcy Court." The basic facts of the case are undisputed, and they are sensational. Judge Jones was in an intimate relationship and living in the same house with a lawyer named Elizabeth Carroll Freeman. Ms. Freeman had worked in Judge Jones's chambers as a law clerk. Subsequently, she was a partner in the Jackson Walker LLP law firm from at least 2017 until December 2022. During this period, members of the Jackson Walker firm regularly appeared before Judge Jones, and Judge Jones approved attorneys' fee awards for that firm totaling more than $9 million, which included more than $1 million in fees for services performed by Ms. Freeman, although she was not shown as a counsel of record on the face of pleadings. As a partner in the Jackson Walker firm, Ms. Freeman obtained a financial benefit from all of the fees approved by Judge Jones, not just from the fees for her services. Jackson Freeman also represented the debtor in cases handled by other bankruptcy judges, where Judge Jones served as a court-appointed mediator. Stunningly, Judge Jones did not recuse himself in any cases where Jackson Walker represented the debtor, nor did he disclose his relationship with Ms. Freeman to the parties or their counsel. So, to sum it up, you have a bankruptcy judge living and sleeping with a law firm partner, whose law firm represented debtors in cases before the judge, and the judge approved fee awards for that law firm totaling more than $9 million, all of which took place over a period of 5 years, with no recusal or disclosure to anyone of the judge's relationship with the law firm partner. Like I said, sensational facts that are almost hard to believe are true, but they are undisputed. This case is a slow-motion train wreck from which most lawyers simply cannot look away. It has raised several issues that call into question the integrity and proper functioning of the bankruptcy system in the United States, and the prominent role that the United States Bankruptcy Court for the Southern District of Texas had come to play in recent years, handling some of the largest bankruptcy filings by well-known companies such as Neiman Marcus, J.C. Penney, and Serta Simmons Bedding. As I am describing the origins of this case, I am going to highlight some of those issues because they are important, but I don't plan to focus on them in our discussion today for 2 reasons. First, I am not a bankruptcy expert, so I very quickly would be wiggling around like a fish out of water talking about, for example, what interested party disclosures are required by law firms and others who provide services to the debtor under the Bankruptcy Code. Second, this scandal has precipitated several lawsuits that are still playing out. Specifically, there is one case filed by the United States Trustee, the Department of Justice's watchdog of the bankruptcy system, seeking to invalidate the attorney's fee awards to Jackson Walker and Ms. Freeman, as well as a civil lawsuit brought by Michael Van Deelen, and you will hear more about Mr. Van Deelen in a few minutes, that asserts federal civil rights and other claims against Judge Jones, Ms. Freeman, Jackson Walker, and also the national law firm of Kirkland and Ellis, so it would be premature to discuss the claims and defenses being litigated in those ongoing cases in any detail. Rather, we are going to focus today on the judicial and legal ethics issues raised by the conduct of Judge Jones and Ms. Freeman. As noted, Judge Jones resigned his judgeship, and it is clear that he did so because he did not want to file a response to a judicial ethics complaint that was lodged against him by the Fifth Circuit Court of Appeals, and we will discuss that complaint in detail. As of this recording, there is no public record of legal ethics charges having been filed against Ms. Freeman, although there is still significant litigation and discovery going on relating to her role in the scandal, as I mentioned. For this reason, when we discuss potential legal ethics claims that could be brought against Ms. Freeman, it is important to make clear first that no such claims yet have been brought, and second, the argument that Ms. Freeman violated the legal ethics rules is far from a slam dunk. In fact, after our discussion today, we may very well conclude that the existing rules have a blind spot for lawyers who fail to disclose a relationship with a judge before whom the lawyer is appearing. Nor have I found any cases where a lawyer has been charged with legal ethics violations for having failed to disclose a romantic relationship with a judge. These are some of the interesting questions we will explore in our legal ethics program today. Let's start with some background to the scandal. This case is important and fascinating for so many reasons, and a fulsome description of the relevant background is needed to understand why. At the risk of offending any of you who practice in Utah or Florida or Ohio, or most other states for that matter, if Judge Jones had been the chief bankruptcy judge in any of those districts, his misconduct would have raised eyebrows and produced a few articles in the legal press, but it would not have been the bombshell that it was because those districts simply are not important as it relates to bankruptcy law and cases. Not so for the Southern District of Texas or its former chief bankruptcy judge, David R. Jones. Cliff White, who used to manage the United States Trustee Program, recently called Judge Jones's actions a body blow to the integrity of the entire bankruptcy system. That is because, at the time the Judge Jones scandal broke, the Southern District of Texas had grown into arguably the most important district in the nation with regard to bankruptcy cases. How did this happen? The answer is largely through the efforts of Judge Jones and his colleague, United States Bankruptcy Judge Martin Isger. Let's start at the beginning of the story, which takes us back to 2016. At that time, the largest corporate bankruptcies in the United States were being filed in one of two districts, the District of Delaware or the Southern District of New York, which includes New York City. That makes sense as these venues traditionally have handled the vast majority of federal cases where corporate governance, mergers and acquisitions, securities litigation, and other complex matters were being litigated between some of the largest companies in the United States. I clerked for a federal district judge in the Southern District of New York, and I saw this firsthand. We routinely handled cases that involved some of the most valuable companies in the United States where tens of millions of dollars or more were at stake. It is therefore surprising that by 2023, Judge Jones had presided over more bankruptcy cases where the debtor had at least $1 billion in debt than any other judge in the nation. As this chart shows, by 2023, Judge Jones had presided over nearly 40 such cases, with Judge Isger in second place with 34, and every other bankruptcy judge in the country, including judges sitting in Delaware and the Southern District of New York, handling less than 1/3 of that number. So, how and why were companies who owed more than $1 billion choosing the Southern District of Texas to file their bankruptcy petitions? The how is easy. In general, companies can choose in which federal district court to file their bankruptcy petitions. Normally, they choose to file in the district where they are incorporated or where the headquarters is located, which would lead most large companies to choose Delaware or the Southern District of New York. But bankruptcy law allows companies to file in any district where they have an office. Most large companies have an office in Houston, and if not, they could create one quickly by incorporating a shell company, opening a bank account, and leasing a post office box. Put another way, the bankruptcy law allows companies to forum shop, and so it not only was possible, but easy for these companies, or more accurately, the lawyers who were advising the companies about where and how to file for bankruptcy protection, to choose the district in which they would file their bankruptcy petitions. In the wake of the Judge Jones scandal, the ability to forum shop is one aspect of bankruptcy law that has come under fire out of concern that it allows insolvent companies to abuse the bankruptcy system at the expense of their creditors by choosing to file in debtor-friendly districts. That's the how of forum shopping in corporate bankruptcy cases. So let's turn now to the why. Why would large companies who are planning to file bankruptcy choose the Southern District of Texas? This is where the story starts to get juicy. As I alluded to earlier, most of the why relates back to Judge Jones and to actions he took to attract these large corporate debtors to his district. Starting in 2016, Judge Jones created a complex case panel system that funneled all large bankruptcy cases filed in the Southern District of Texas, either to him or to Judge Isger. Judge Isger, along with another lawyer named Tom Kirkendall, had given Judge Jones his first job as a lawyer, and they were close personal friends. Judge Isger has a part to play in Judge Jones's failure to disclose his relationship with Ms. Freeman that we will explore later, and interestingly, it is Mr. Kirkendall who is currently representing Judge Jones in the litigation pending against him by Michael Van Deelen. In addition to their friendship, Judges Jones and Isger also shared a goal of making the Southern District of Texas an attractive venue for large companies to file for bankruptcy. By implementing a case management system that would funnel all large cases to one of them, they had the ability to determine the level of service and the substantive rulings that these companies and their lawyers would receive should they choose to file in their district. In the years after Judge Jones created the complex case system, the Southern District of Texas quickly attracted large bankruptcy cases that otherwise would have been filed in the District of Delaware or the Southern District of New York. In one of the Financial Times articles that came out after the scandal broke, the reporter wrote that the Houston bankruptcy boom created a mini windfall for the local economy, with scores of bankruptcy professionals descending from all over America for hearings. Judge Jones had done more for that economy in the last 10 years than just about anyone, says one hedge fund executive only half jokingly. He should be the mayor of Houston. Soon after setting up the complex case system, Judge Jones contacted two of the top bankruptcy partners at the national law firm of Kirkland & Ellis and invited them to a meeting in his chambers. Nobody knows exactly what was said at the meeting, but what resulted quickly became apparent to anyone who was paying attention, but not many people were paying that much attention at the time. In 2016, when low oil prices forced many Texas oil drillers into insolvency, Kirkland began filing the largest of those bankruptcy cases in Houston. Kirkland did the same thing a few years later when COVID-19 closures pushed large retailers JCPenney and Neiman Marcus into bankruptcy. Kirkland, in turn, hired Jackson Walker as its local counsel in most of these cases, and Ms. Freeman was by that time a partner at Jackson Walker, and she worked on many of those cases, while other law firms with significant bankruptcy practices, including Latham & Watkins and Weil Gotshal, also brought their biggest cases to Houston. Kirkland accounted for more than half of the cases that were filed in the Southern District of Texas, while Judge Jones was in charge. The Wall Street Journal also reported that Judges Jones and Isger forged social ties with the lawyers at Kirkland, sharing drinks and meals together, but the article is short on specifics, and there is no suggestion that Kirkland or its lawyers had any improper relationship with Judges Jones or Isger. There is an allegation that Kirkland knew about Ms. Freeman's relationship with Judge Jones, but Kirkland fervently disputes that claim, and to date, no evidence has been produced to establish that knowledge as it relates to Kirkland. There is no doubt, however, that Jackson Walker was aware of the relationship between Judge Jones and Ms. Freeman, although the firm now contends that it was misled by Ms. Freeman in certain key respects. For now, it is enough to point out that Kirkland chose to steer most of its large bankruptcy cases to the Southern District of Texas and to hire Jackson Walker as its local counsel in at least 25 of those cases, even though, and oddly enough, Kirkland already has an office in Houston. Why would Kirkland hire Jackson Walker as local counsel in all of these cases if it didn't believe by doing so it was setting up their clients for more favorable treatment by Judge Jones by hiring his favorite local law firm? In any case, it is clear that Kirkland's decision to send their biggest cases to Houston was the primary reason that the Southern District of Texas became the preeminent bankruptcy court in the United States by 2023. Interestingly, since the scandal broke, Kirkland has filed their largest bankruptcy cases on behalf of debtors Bed Bath & Beyond, Rite Aid, and WeWork in the District of New Jersey. I guess the party for debtors is over in Houston, but maybe another party is starting up in Newark? So, what could law firms like Kirkland expect in terms of how bankruptcy cases were handled in the Southern District of Texas under Judge Jones? In a nutshell, favorable treatment for the debtors that they represented, and that favorable treatment could result in billions of dollars of savings for their clients. As the Financial Times reported, quote, top corporate lawyers and investment bankers gravitated to his court, where swaggering private equity firms and hedge funds won and lost fortunes in complex legal chess matches. Jones had made Houston, and by extension himself, the epicenter of U.S. corporate bankruptcy litigation, end quote. I'm a big fan of the Houston court, says a well-known financial advisor who has appeared in several cases before the judge. Judge Jones entirely changed the paradigm of a sleepy court, where you had to wait around and feel like you were dealing with government bureaucracy, this advisor adds. Houston brought a service orientation to the bankruptcy court system. They woke up Delaware and the Southern District of New York. In court hearings, Judge Jones was warm and friendly towards all participants, and was especially solicitous, as one lawyer put it, towards the big-time advisors from New York, Los Angeles, and Chicago, who appeared in front of him, eager to heap praise upon their written briefs and oral arguments. He made us look good in front of our CEO clients and also the junior lawyers on our team, says the person. Jones also was popular for almost never pushing back on creeping fees for advisors. In short, Judge Jones took very good care of the lawyers who appeared before him, and they, in turn, kept choosing to file their cases in his district. This process went on for more than 5 years as Houston grew into the preeminent bankruptcy court in the United States. It wasn't just his pleasant demeanor, the higher level of service he provided to debtors and their counsel, or his willingness to approve steadily rising fees. Judge Jones seemingly went out of his way to rule on key issues in favor of the debtors, and to the detriment of their creditors. 2 cases are cited in the reporting in support of this conclusion, but you don't really need proof, because the literal gold rush of case filings that occurred in the Houston court during this period themselves are the proof. If Judge Jones wasn't routinely ruling in favor of debtors and against creditors, there is no reason why debtors would be flocking to his district in droves. To paraphrase a familiar saying, if you build a bankruptcy court that systematically favors debtors, they will come. That said, I am not a bankruptcy expert, so I have no idea if these rulings in fact were contrary to the law or the prevailing practice in bankruptcy cases. I also am certain that it would be unfair to judge any judge by cherry-picking 2 of his rulings out of thousands he has made over his career. Accordingly, I am just going to tell you about these 2 cases and let you draw your own conclusions. The first case is the 2020 bankruptcy of fracking pioneer Chesapeake Energy. A group of unsecured creditors argued to Judge Jones that Chesapeake was worth enough to allow them to own a piece of it after the restructuring. In support of their motion, the creditors offered testimony from a distinguished expert witness, a co-author of a valuation guidebook for the American Bankruptcy Institute, who testified that the company was worth roughly $7 billion. Judge Jones ruled that Chesapeake was worth only about $5.1 billion, which was closer to the company's preferred valuation. When a lawyer representing Chesapeake asked Judge Jones to share his calculation, Judge Jones responded, "Not a chance." Judge Jones's ruling meant that these creditors would be left with almost nothing. 1 month later, when Chesapeake relisted itself on the NASDAQ after emerging from bankruptcy, the market valued the company at $7.7 billion. "There is simply no ambiguity in my mind," said Judge Jones, as he made a ruling in May 2022 in the bankruptcy case of Serta Simmons Bedding, a large, private, equity-backed mattress company. The second case cited as an example of Judge Jones's bias in favor of debtors. Judge Jones continued, And I appreciate that perhaps a different court reached a different conclusion, but again, I sit with these matters every single day. This is very easy for me. Judge Jones's decision cleared the way for a slim majority of creditors to take control of the company and leave another group's holdings close to worthless. Serta Simmons Betting itself would go on to quickly exit court supervision as the company wished. In the oral ruling, Jones had preempted an ongoing lawsuit over the Serta Simmons Betting bankruptcy gambit that was winding its way through an arguably more senior federal district court in New York, prompting many lawyers and legal scholars to both grumble and marvel at what they regarded as a power play predicated upon cavalier legal reasoning. To plant a flag on top of his rising mountain of hubris, Judge Jones excoriated people in court for potential conflicts of interest. In the bankruptcy of coal producer Westmoreland, he criticized the company's advisor McKinsey for failing to disclose its connections to clients with a financial interest in the case. The only thing I want to tell you all is the bankruptcy process itself is extremely, extremely fragile, Judge Jones said in court. If I can't trust the professionals that appear before me, then the process won't work. So, we have the pot calling the kettle black, and as the saying goes, pride goeth before the fall. Paradoxically, nearly all of Judge Jones's rulings are now being re-examined in light of the obvious conflict of interest between himself on the one hand and Ms. Freeman and the Jackson Walker firm on the other hand. In addition, the revelation of his conflict of interest has resulted in 3,500 bankruptcy cases being reassigned to other judges in the Southern District of Texas. But this scandal has raised questions more broadly about the immense power and wide discretion that bankruptcy judges wield, and what can happen if they choose to exercise that power and discretion in ways that favor the debtor over its creditors. Hopefully, this case will be a catalyst for change in the bankruptcy system where any ability to abuse that system could have dire consequences in cases where billions of dollars often are at stake. With that background, let's turn now to how the scandal broke and to our discussion of the judicial and legal ethics issues that it raises. Ironically, it was not the largest or most well-known bankruptcy cases like Neiman Marcus or J.C. Penney that unearthed the scandal that brought down Judge Jones, but rather, it was one of the smallest, and it was one of the smallest players in that small case, a retired high school teacher named Michael Van Deelen, who was almost single-handedly responsible for bringing down Judge Jones. It was truly David versus Goliath, but in this case, David had better ammunition than a slingshot. Mr. Van Deelen had received in the mail an anonymous letter that revealed the romantic relationship between Judge Jones and Ms. Freeman, and accused both of them and the Jackson Walker law firm of corruption by purposefully steering cases to Judge Jones, who would rule systematically in favor of those clients. According to reporting by the Wall Street Journal, Judge Jones first crossed paths with Mr. Van Deelen during the 2020 bankruptcy hearings for McDermott International, an offshore oil and gas engineering company. McDermott was represented by Kirkland, and Jackson Walker was co-counsel. Van Deelen, an investor in the company, accused McDermott's management of fraud. Van Deelen was angry over a bankruptcy plan from Kirkland and approved by Judge Jones that wiped out Mr. Van Deelen's $146,000 investment in McDermott, and his frequent outbursts in court irritated Judge Jones. After a hearing in March 2020, Judge Jones said he overheard Mr. Van Deelen call him a son of a bitch, which Mr. Van Deelen denied. According to court papers, Kirkland lawyers said they also heard the remark. After that, Jones banned Mr. Van Deelen from the courtroom unless he was accompanied by a security officer. Jones also referred him to federal prosecutors for possible investigation. To quote Taylor Swift, there clearly was bad blood between Judge Jones and Mr. Van Deelen as a result of the McDermott bankruptcy case. I describe Mr. Van Deelen as a David figure because he had the courage to stand up to a Goliath in the form of Chief Bankruptcy Judge David R. Jones, who had been described as the mayor of Houston, and also because, like David, he won the battle. But that is where the similarities end. In a world where we like our heroes to be pure good and our villains pure evil, Mr. Van Deelen isn't all good, and in that respect, he's just like most people. Were it not for his success in bringing down Judge Jones, He might have gone down in history as a bit of a crank, and a highly litigious one at that, who has been sanctioned by several courts for filing lawsuits that lack merit. Mr. Van Deelen previously had filed lawsuits against a volunteer baseball association that had suspended him from coaching a little league team, against a prosecutor who had charged him with assault, against a school district that had barred him from school property because he had used inappropriate language and obscene hand gestures towards teachers, students, and the principal of another school at a wrestling match, and finally, against 6 state court judges after one judge had informed him that, because of his oral threat to sue the state judge, all communication should be in writing. Furthermore, he had been sanctioned in multiple cases, including one case for fabricating evidence and in another for violating Rule 11. I think this is all you need to know to get a fairly accurate picture of who Mr. Van Deelen is, because at the end of the day, our story is focused on Judge Jones and Ms. Freeman. In this case, however, Mr. Van Deelen was 100% right to accuse Judge Jones of bias, and his pugnacious refusal to give up in the face of a judicial cover-up, not only by Judge Jones but by others in the Southern District of Texas, is the reason this scandal came to light. Back to the Wall Street Journal's reporting. Mr. Van Deelen filed a motion in July 2020 seeking to remove Judge Jones from the McDermott case, alleging the judge made a false accusation and was biased against him. In March 2021, an envelope with no return address arrived in Mr. Van Deelen's mailbox. The unsigned letter inside had a title, Corruption Involving Judge David R. Jones. This is the anonymous letter I mentioned before that gave Mr. Van Deelen the ammunition he needed, although due to the cover-up I just mentioned, it would take almost 2 more years until 2023 for the truth to come to light. Bloomberg Law, in an article entitled, How 4 Judges Kept Romance Allegations Quiet for 2 Years, did some excellent reporting to reveal the extent of the cover-up. Quote, the bankruptcy system is supposed to be transparent, but the letter was kept out of the public eye for more than 2.5 years. At least 4 judges kept the document sealed or suppressed efforts to examine the allegations, Bloomberg Law found. Some went so far as to direct Mr. Van Deelen to not publicly discuss its contents, end quote. As we learned from Watergate, it's not necessarily the crime that gets you, it's the cover-up, although to date, of the 4 judges who participated in the cover-up, none has suffered any consequences arising from their actions except for Judge Jones. Here's the chronology of the cover-up as reported by Bloomberg Law. After getting the letter, Mr. Van Deelen emailed Matthew Kavanaugh, Jackson Walker's co-counsel on the McDermott case. Mr. Kavanaugh asked the court to seal the letter. As Mr. Van Deelen pushed to remove Judge Jones from the McDermott case, the judge referred the motion for reassignment to Judge Isgur. Judge Isgur took the matter himself and ordered the letter sealed until it could be admitted into evidence. Meanwhile, Mr. Kavanaugh moved to internally address the letter's allegation that the relationship benefited the firm. He reached out to Jackson Walker's general counsel and other attorneys there to look into the allegations. Ms. Freeman has since said in a court filing that neither Jackson Walker nor Kirkland knew about the relationship when McDermott filed for bankruptcy in January 2020. Ms. Freeman confirmed to Jackson Walker that there had been a romantic relationship with Judge Jones in the past. Jackson Walker told Ms. Freeman to stop work on all matters in Jones's court while it looked into the issue. Mr. Van Deelen's March 2021 correspondence and court filing were the first time Jackson Walker heard of the relationship, said its spokesman Jim Wilkinson. The firm acted responsibly and promptly once it learned of the issue, he said. At a court hearing 4 days after Mr. Van Deelen sent the letter to Jackson Walker, no one from the firm confirmed that it was aware Ms. Freeman had been in a prior relationship with the judge. Judge Isgur rejected Mr. Van Deelen's push to take depositions to investigate the letter's veracity. I'm not going to let you take a deposition about the contents of an anonymous letter, Judge Isgur said. That would be totally outrageous. Judge Isgur also said Mr. Van Deelen couldn't discuss the letter's substance, calling its contents inadmissible hearsay, and also denied the motion to recuse Judge Jones. It's not clear whether Judge Isgur had asked Judge Jones, his friend and colleague for decades, if the letter's contents were true. According to the Wall Street Journal, when a Texas federal court official questioned Judge Isger after the scandal broke, Judge Isger said he had no inkling about Judge Jones's relationship with Ms. Freeman. Judge Isger said Judge Jones typically didn't invite him into his house when he picked him up or dropped him off because Judge Jones had an aggressive dog, according to a person familiar with the conversation. To me, this sounds like an aggressive dog ate my homework type of excuse, particularly for someone who has been friends and colleagues with Judge Jones for decades and apparently drove together with him to and from work. The notion that he didn't know that Judge Jones was living with Ms. Freeman seems hard to believe, but I leave that to you to decide. So, the first judge to participate in the cover-up was Judge Isger. Bloomberg Law continues with the chronology. With the letter's allegations diffused for the time being, Jackson Walker continued looking into the relationship and instructed Ms. Freeman to stay off matters before Judge Jones. Ms. Freeman told Jackson Walker the romantic relationship had ended sometime prior to March 2020, according to a draft of the firm's internal review that it later filed in court. Ms. Freeman said she and Judge Jones owned their own homes and had never lived together. She also said they had no current romantic relationship and that none is expected going forward, the internal review states. Jackson Walker took several actions, including saying Ms. Freeman couldn't receive any firm profits from Jones's cases. Meanwhile, Jackson Walker's motion to seal the anonymous letter remained pending until September 2021, when Judge Jones granted it himself, writing that the letter shouldn't be made available without a court order, including to any Freedom of Information Act requests. So, the second judge to participate in the cover-up was Judge Jones himself, who of course was doubly conflicted, first by his sexual relationship with Ms. Freeman and the Jackson Walker firm, of which she was still a partner at that time, and second, by the fact that he is ruling on the sealing of a letter that relates to a motion to reassign the McDermott case to another judge. Incredible stuff. Let's continue as Bloomberg Law leads us through the rest of the story, where the cover-up ultimately failed and the scandal finally broke in October 2023. In March 2022, Jackson Walker received another accusation about the relationship, one that made attorneys there wonder if Ms. Freeman's denial was possibly false, according to a court filing from the firm after the accusations became public. The firm questioned Ms. Freeman again and she admitted the relationship had resumed, Jackson Walker said in the filing. Ms. Freeman retained Tom Kirkendall, Judges Jones and Isger's former law partner. In spring 2022, he urged Jackson Walker to disclose the relationship and even prepared a draft disclosure for the firm, which he said would force Judge Jones to reveal it. Still, no one involved publicly disclosed that Judge Jones and Ms. Freeman were together. By December 2022, Ms. Freeman left Jackson Walker to open the law office of Liz Freeman. Meanwhile, Mr. Van Deelen's press to seek out the truth continued hitting judicial dead ends. In January 2023, U.S. District Court Judge Andrew S. Hainan ruled that the anonymous letter was properly sealed and that its sender and scurrilous allegations perhaps cannot be verified. This form of unsupported character assassination has no place in any court proceeding, he wrote. So Judge Hainan is our third judge to take part in the cover-up of the anonymous letter. Let's go back to Bloomberg Law to reveal our fourth judge. Determined, Mr. Van Deelen again sued Judge Jones in United States District Court on October 4, 2023, related to his actions in the McDermott case. The case, assigned to District Court Judge Keith P. Ellison, again included a copy of the anonymous letter, and this time, Mr. Van Deelen attached as further proof information he found showing that Judge Jones and Ms. Freeman had owned a home together since at least 2017. The complaint remained publicly unavailable, sealed without request by Judge Ellison due to, quote, judicial security, end quote. Judge Ellison told Bloomberg Law he expected he was going to be disqualified from the Van Deelen case and kept the complaint sealed to preserve the status quo. David is a colleague and we can't hear cases from colleagues in our district, he said. And then plus he's a friend beyond that. Business Insider got a copy of the motion and published a story about it on October 6th. The next day, Judge Jones confirmed the relationship to the Wall Street Journal. He said it didn't need to be disclosed because they weren't married, and, quote, there was no economic benefit to him from her legal work, end quote. Thus, our fourth judge is Judge Ellison, although you may choose to believe his explanation that he was merely seeking to preserve the status quo until he could recuse himself from hearing a case involving his friend and colleague, Judge Jones. As I mentioned, apart from Judge Jones, none of the 4 judges has been accused of misconduct or suffered any consequences as a result of their rulings in the McDermott case concerning the anonymous letter. So 2 things are critically important in this last part of the story. First, Mr. Van Deelen found proof from an online database containing public real estate records that Judge Jones and Ms. Freeman had owned a home together since at least 2017. This appears to contradict Ms. Freeman's statements to Jackson Walker that she and Judge Jones didn't live together. Later, it was revealed that Ms. Freeman paid 1/2 of the property taxes on the home, which confirmed that Judge Jones benefited financially from fees that Ms. Freeman collected as a Jackson Walker partner, attorney's fees that Judge Jones himself had approved. Recall that those fees totaled more than $9 million over a period of 5 years. Second, we had Judge Jones for the first time admitting that he and Ms. Freeman were in a sexual relationship while offering his defenses that the relationship didn't need to be disclosed because they were not married and because he did not benefit from her legal work. The former is not the standard for judicial disqualification, and the latter is not true, and we will turn next to an analysis of Judge Jones's conduct under the canons of judicial ethics. To cut to the chase, Judge Jones violated at least 7 canons of the Code of Conduct for United States judges, which regulates the conduct of federal district and circuit court judges, in addition to bankruptcy judges. Explaining how Judge Jones violated the applicable canons of judicial conduct is easy because the Fifth Circuit Court of Appeals has done all of my work for me. As soon as Judge Jones admitted the relationship to the Wall Street Journal, the Fifth Circuit initiated an investigation of Judge Jones, and a little more than a week later, Chief Judge of the Fifth Circuit Priscilla Richmond issued a complaint finding that she had found probable cause that Judge Jones had committed misconduct regarding his intimate relationship with Ms. Freeman. Here is the pertinent part of Judge Richmond's order. Based on the foregoing facts, there is probable cause to believe that Judge Jones has engaged in misconduct. In particular, the Code of Conduct for United States Judges provides in Canon 2 that a judge should avoid impropriety and the appearance of impropriety in all activities. All of the alleged conduct set forth above appears to constitute impropriety, or at least the appearance of impropriety. Article 2. Canon 2b provides in part that a judge should not allow family or other relationships to influence judicial conduct or judgment. 3. Canon 3c(1) provides that a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned. 4. Canon 3c(1) provides a non-exclusive list of circumstances in which a judge should disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned. Included in the list, in subsection 3c, 1c, is an instance in which the judge knows that the judge or the judge's spouse has a financial interest in the subject matter in controversy or in a party to the proceeding, or any other interest that could be affected substantially by the outcome of the proceeding. 5. The non-inclusive list also includes, in Canon 3c, 1d, instances in which the judge or the judge's spouse, or a person related to either within the 3rd degree of relationship, or the spouse of such a person is, 2. Acting as a lawyer in the proceeding, or 3. Known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. 6. The commentary to Canon 3c, 1d, 2 provides, the fact that a lawyer in a proceeding is affiliated with a law firm with which a relative of the judge is affiliated does not of itself disqualify the judge. However, if the judge's impartiality might reasonably be questioned under Canon 3c(1), or the relative is known by the judge to have an interest in the law firm that could be substantially affected by the outcome of the proceeding under Canon 3c, 1d, 3, the judge's disqualification is required. And 7. Canon 3b(3) provides in 3. That a judge should exercise the power of appointment fairly and only on the basis of merit, avoiding unnecessary appointments, nepotism, and favoritism. Unlike the 3 other judges who sought to cover up the anonymous letter to protect Judge Jones, Judge Richmond made her complaint against Judge Jones public, reasoning that, quote, disclosure of the existence of this complaint is necessary and appropriate, particularly because many of the allegations regarding Judge Jones's conduct have been made public in the press and in the filing of a lawsuit against Judge Jones, end quote. The judicial misconduct case against Judge Jones was a slam dunk, so much so that he quickly resigned so that he did not have to answer Judge Richmond's complaint. Interestingly, when a federal judge resigns, whatever judicial ethics complaints are pending against the judge get dismissed as moot, and that is what happened to the complaint against Judge Jones. The reason is that once the judge is no longer a judge, he or she is no longer subject to the disciplinary procedures applicable to judges who violate the Code of Conduct for United States judges. This is yet another area where the Judge Jones scandal has raised calls for reform. Commentators have started calling for changes to the Judicial Conduct and Disability Act to allow for ethics inquiries to continue beyond the resignation of the judge. These commentators note that public confidence in the judiciary is at an all-time low, and for this reason it is important that judges be held fully accountable for their unethical actions. This certainly seems sensible to me, although I do not purport to be any sort of expert in judicial ethics. Since the judicial ethics case against Judge Jones is an easy one, and also a moot one now that the judge has resigned, I think the most interesting question to explore is how could a smart lawyer like Judge Jones possibly get himself into this situation? And more than that, how could he justify to himself his failure to recuse himself in cases involving Ms. Freeman and Jackson Walker, or even to disclose his relationship with her to the parties in those cases? The most interesting and insightful analysis I have read to help us answer these questions comes from Professor Robert Prentice, who teaches at the McCombs School of Business at the University of Texas at Austin. Here is Professor Prentice's take, quote, "You might be asking yourself how Judge Jones could have gotten himself into this position, and how he could have offered up such transparently lame explanations for his failure to disclose and recuse. The answer is possibly that Judge Jones simultaneously really wanted A, his job, B, his romantic relationship with Freeman, and C, the money, the $750 an hour that Freeman was making working on the cases before him. Screw the code of conduct, he might have said to himself. However, as Leonard Mlodinow has noted, our culture likes to portray situations in black and white. Antagonists are dishonest, insincere, greedy, evil. They are opposed by heroes who are the opposite in terms of those qualities. But the truth is, from criminals to greedy executives to the nasty guy down the street, people who act in ways we abhor are usually convinced that they are right," end quote. As we saw with Mr. Van Deelen, our heroes are not always the people who do everything right. Professor Prentice continues, quote, "More likely, the self-serving bias, reinforced by the overconfidence bias, enabled Judge Jones to convince himself that his actions were permissible. He probably didn't realize that a different part of his brain judges the propriety of his own actions than judges the actions of others. The self-serving bias affects how people, including judges, collect, process, and even remember information. It often makes what we perceive to be best for us to seem to us to be what is best. The overconfidence bias is our tendency to be more confident in our moral character and judgment than is objectively reasonable, often believing, for example, that we will not fall prey to conflicts of interest, though suspect others will," end quote. I think this fits very well with the example I cited earlier about Judge Jones aggressively going after anyone who appeared before him that he believed to be suffering from a conflict of interest when he himself was the most conflicted of anyone. I think Professor Prentice is spot on in terms of identifying these two psychological biases as having been at work in Judge Jones's case. Now, to my knowledge, Professor Prentice is not a psychologist and he never interviewed Judge Jones. Nor do I intend this program to offer explanations for Judge Jones's conduct that would be psychologically valid. My point only is that lawyers, like all humans, search for explanations when we see others behaving in ways that break our norms, whether that be criminal conduct or, in the case of Judge Jones, judicial misconduct. I think Professor Prentice's analysis helps us to do that in this case, and so I offer it to you for that purpose. To sum it all up, here is Professor Prentice one last time quote. The evidence is clear that human beings who consider themselves to be good folks can convince themselves that it is okay for them to do a bad thing. The evidence currently available certainly points to Judge Jones screwing up very badly indeed, but probably not intentionally. His mind likely constructed a world in which the failure to disclose was perfectly permissible. End quote. With that, and in the time we have left, we'll leave Judge Jones and turn our attention to Ms. Freeman and whether her conduct may have violated the legal ethics rules. Two things to mention before we explore this topic. First, as I mentioned at the outset, no legal ethics claims have been brought to date against Ms. Freeman, and many of the facts about her role in these matters, including what she told Freeman Walker and when she told it to them, is still being determined in the various legal proceedings, which are ongoing. Second, lawyers representing Ms. Freeman have said in court filings that she had no legal duty to disclose her relationship with Judge Jones. To date, no court has ruled on the validity or invalidity of that claim, nor have I been able to find any cases where a lawyer has been charged with legal ethics violations for having failed to disclose a romantic relationship with a judge. Based on my review, I think that the argument that Ms. Freeman violated the legal ethics rules is far from a slam dunk. In fact, I think that the existing legal ethics rules have a blind spot for lawyers who fail to disclose a relationship with a judge before whom the lawyer is appearing. Ostensibly, that is because the existing codes of judicial conduct expect and require the judge to recuse himself or herself in those cases. And so the drafters of our legal ethics rules didn't think it was necessary also to require the lawyers to disclose the relationship or withdraw from the matter. Whereas here the judge does something unexpected and fails either to recuse himself or to disclose the relationship, it is unclear if the lawyer's failure to disclose her relationship with the judge or to withdraw violates any of the legal ethics rules. Let's start by thinking about what legal ethics rules Texas State Bar officials could cite as potentially violated by Ms. Freeman based on the conduct we've outlined here today. For simplicity, I'll refer to the ABA model rules because the Texas disciplinary rules of professional conduct follow the ABA model rules, and the rules we are going to discuss today are functionally equivalent. But before we consider some possibilities, at the highest level, it just seems wrong what Ms. Freeman allowed to happen here. And I think everyone would agree that lawyers should not put themselves and should not allow others to put them into the situation Ms. Freeman occupied here for any period of time, much less for more than 5 years. That said, is it possible to make a general appearance of impropriety argument against Ms. Freeman in terms of making out a violation of the legal ethics rules? Judge Jones, of course, is ethically obligated to avoid situations that cause such an appearance as we saw when we reviewed the canons of ethics that apply to federal judges. But does she have a legal ethics duty to avoid impropriety or the appearance thereof? Neither the ABA model rules nor the Texas disciplinary rules of professional conduct contain any general requirement that lawyers avoid impropriety or the appearance of impropriety. My joke here is that if the legal ethics rules required such a thing, half of the bar would be in violation of the rule at any given time, and the other half would be ethically required to report the first half to the state bar pursuant to the duty to report lawyer misconduct under ABA Model Rule 8.3, which is affectionately known as the RAT Rule. If you are interested in hearing more about the RAT Rule, I did a legal ethics presentation on it recently that likely is available on the same service where you are viewing this program. The first area where you might think a legal ethics claim might lie against Ms. Freeman would be in the rules that require lawyers to avoid conflicts of interest. For example, there is ABA Model Rule 1.7 entitled Conflict of Interest Current Clients that provides as follows: A, except as provided in paragraph, B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or 2. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Section A1 doesn't apply because Ms. Freeman's representation of debtors before Judge Jones didn't raise any conflict concerns based on her representation of other clients. Section A2 could apply if her representation of the debtor would be materially limited by her responsibilities to a third person or by a personal interest of the lawyer, if that third person was Judge Jones, or her personal interest was her romantic relationship with Judge Jones, and things were not going well between them. But here the opposite is true. It is likely that Ms. Freeman, the Jackson Walker firm, and the debtors they were representing were getting more favorable treatment and rulings from Judge Jones as a result of the consensual and ostensibly happy romantic relationship between Judge Jones and Ms. Freeman, as opposed to the client suffering any prejudice. Accordingly, I don't believe Ms. Freeman violated ABA Model Rule 1.7 or any of the other rules that deal with conflicts of interest. The second area where you might think a legal ethics claim might lie would be in the rules that require lawyers to be candid when appearing in court. For example, there is ABA Model Rule 3.3 entitled Candor Toward the Tribunal that provides in pertinent part as follows. A lawyer shall not knowingly, 1. Make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. But in this case, Judge Jones was fully aware of all of the facts regarding his relationship with Ms. Freeman, so there were no false statements being made to the tribunal, and while Ms. Freeman's surreptitious romantic relationship with Judge Jones certainly was untoward, there is no suggestion that her conduct was criminal or fraudulent. So again, I don't think any legal ethics claim could be brought against Ms. Freeman under ABA Model Rule 3.3 or any of the other rules that deal with making false statements to a court. The next area that might be implicated are the rules that require lawyers to be truthful in their dealings with others. There are two rules to discuss here, ABA Model Rules 4.1 and 8.4. First, ABA Model Rule 4.1, entitled Truthfulness in Statements to Others, provides that in the course of representing a client, a lawyer shall not knowingly A. Make a false statement of material fact or law to a third person, or B. Fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. For ABA Model Rule 4.1, A to apply, you need a false statement of material fact or law to a third person. And there is no direct proof that Ms. Freeman made any false statements of material fact to any third person concerning her romantic relationship with Judge Jones. That said, there have been allegations, including some advanced by Jackson Walker, that Ms. Freeman misled them about the nature and timing of her relationship with Judge Jones, namely, that she had told them that the relationship had ended in March 2020, when in fact it had not, and that she was not living with Judge Jones, which also appears not to have been true. If Ms. Freeman is shown to have made false statements to Jackson Walker, it is possible that she violated ABA Model Rule 4.1a. Another possible path to finding liability for Ms. Freeman under ABA Model Rule 4.1a is comment number 1 to the rule, which states that a lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts. A misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. Misrepresentations can also occur by partially true but misleading statements or omissions that are the equivalent of affirmative false statements. For dishonest conduct that does not amount to a false statement, or for misrepresentations by a lawyer other than in the course of representing a client, see Rule 8.4. The comment makes clear that Ms. Freeman had no duty to inform any opposing parties, which could be the creditors in cases where she represented the debtor or arguably Jackson Walker when the firm was investigating her conduct once the anonymous letter surfaced, of relevant facts, so I think she is okay there. The parts of the comment that make clear that, quote, a misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false, end quote, and that, quote, misrepresentations can also occur by partially true but misleading statements or omissions that are the equivalent of affirmative false statements, end quote, could be problematic for Ms. Freeman, depending on what she said to third parties about her relationship with Judge Jones, including statements to Jackson Walker during the firm's investigation. As we sit here today, there is no direct proof of false or misleading statements by Ms. Freeman, but these matters are still being litigated in the two pending cases I mentioned earlier. Section B is unlikely to apply to Ms. Freeman because you need to have a criminal or fraudulent act by a client before a lawyer can be cited for having failed to disclose a material fact to a third person. As noted, there is no claim of a criminal act or fraud here by either Judge Jones or Ms. Freeman. Nor is there any claim that the debtors Ms. Freeman represented were aware of her relationship with Judge Jones, and if they were unaware of it, there would be no basis to claim that the debtors were seeking to commit fraud. Accordingly, and based on the information that has come to light so far, Ms. Freeman does not appear to have violated ABA Model Rule 4.1, although that very well could change as facts continue to be revealed and proven up in the pending court cases. Next, we have ABA Model Rule 8.4 entitled Misconduct, which provides in pertinent part that it is professional misconduct for a lawyer to b. commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, c. engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, d. engage in conduct that is prejudicial to the administration of justice, or f. knowingly assist a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law. The lack of a criminal act or discriminatory conduct on Ms. Freeman's part makes much of ABA Model Rule 8.4 inapplicable, but there are three sections that could be a problem for her. ABA Model Rule 8.4c prohibits lawyers from engaging in, quote, conduct involving dishonesty, fraud, deceit, or misrepresentation, end quote. Similar to our analysis of ABA Model Rule 4.1, if Ms. Freeman lied or made, quote, partially true but misleading statements or omissions that are the equivalent of affirmative false statements, end quote, she could have liability under ABA Model Rule 8.4c for having engaged in dishonesty or misrepresentation. There is no proof of that yet, but it very well could be proved before everything is said and done. ABA Model Rule 8.4d that bars lawyers from engaging in conduct that is, quote, prejudicial to the administration of justice, end quote, also could be a problem for her. There isn't much guidance on what is covered by this language, but you could make an argument that the role Ms. Freeman played in the scandal, which has caused nearly all of Judge Jones's rulings to be re-examined, and 3,500 pending bankruptcy cases to be reassigned to other judges in the Southern District of Texas, qualifies as conduct that is prejudicial to the administration of justice. My sense is that a legal ethics claim under this section wouldn't be enough, standing alone, to make a case against Ms. Freeman, but it very well could be thrown in and possibly sustained if Texas state bar officials do decide to bring legal ethics charges against her on other grounds. Finally, and I've saved the best or really the worst for last, we have ABA Model Rule 8.4f that bars lawyers from, quote, knowingly assisting a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law, end quote. There can be no doubt that Judge Jones violated the judicial ethics rules. So, did Ms. Freeman knowingly assist him in that conduct, or was she merely a bystander who failed to blow the whistle on Judge Jones for obvious reasons? I think it's a close call, mostly because Judge Jones was the one who had the duty to recuse himself, or at least to disclose the relationship, so that the parties could move to disqualify him versus Ms. Freeman, who had no duty to withdraw or to disclose. On the other hand, Ms. Freeman gained a substantial financial benefit from the relationship, so she was not a mere bystander, combined with the fact that the relationship and failure to disclose it went on for a period of more than 5 years. You could add to the mix any lies or misrepresentations Ms. Freeman may have told to third parties, including to Jackson Walker, where she was a partner, and to which she owed fiduciary duties, if any such lies or misrepresentations are later established, that could tip this one against Ms. Freeman. One obstacle to bringing legal ethics charges under this section is that because Judge Jones resigned the bench, there is no finding that he violated the judicial ethics rules, although everyone knows that he did. Accordingly, any legal ethics claim against Ms. Freeman based on this provision would need to prove those underlying judicial ethics violations, and that might not be as easy as it seems. For example, could Judge Jones assert his Fifth Amendment right against self-incrimination and refuse to testify in proceedings that tried to prove up those claims? Perhaps he would have to testify because he can't be punished now that he has resigned, similar to a criminal defendant who is given immunity as part of a plea deal. So perhaps he couldn't take the Fifth and would have to testify under oath. It's an interesting question, and the result is not entirely clear. To summarize, I think that the argument that Ms. Freeman violated the legal ethics rules is far from a slam dunk, and that the existing rules have a blind spot for lawyers who fail to disclose a relationship with a judge before whom the lawyer is appearing. Ms. Freeman could have liability under ABA Model Rules 4.1 and/or 8.4 if she lied or made partially true, but misleading statements or omissions that are the equivalent of affirmative false statements to Jackson Walker or other third parties. But that has not been established so far, although there is a lot of circumstantial evidence suggesting that she did. Ms. Freeman probably has the most potential exposure under ABA Model Rule 8.4F, that bars lawyers from knowingly assisting a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law. But bringing a charge under that section could have substantial problems of proof if Judge Jones is not required to testify and his underlying judicial ethics violations cannot otherwise be proven. Lastly, Ms. Freeman could face a legal ethics claim under ABA Model Rule 8.4D. that bars lawyers from engaging in conduct that is prejudicial to the administration of justice as an add-on claim. But in my view, a violation of that section, standing alone, is unlikely to be enough to bring a legal ethics case against her. It is also important to remember two things as we close. I have not found any cases where a lawyer has been charged with legal ethics violations for having failed to disclose a romantic relationship with a judge, and to date, Ms. Freeman has not been charged with any legal ethics violations. That may change once all of the facts surrounding the scandal come to light and the pending litigations have been finally resolved. With that, we've reached the end of our time today. I hope you enjoyed today's program, and thanks for joining me.